Aloha. Welcome to Ably Seminar session. Today, we're going to talk about wills and descent. And you go, okay, what happens with a will? And why do you have a will? A will is a legal document that is usually drafted by an attorney, and the person that's making the will tell the attorney, when I die, I want my assets to go to the following people. And the person that's making the will, called a testator, would tell the attorney what percentage of ownership he wants to give to each heir. So this will is done while you're alive, but it will not go into effect until you pass away. And properties that are held in tenants in severalty and tenants in common are controlled by the will. So let's say I have a will, and I decided who's going to get what assets. So I'll usually appoint what I call a personal representative to administer the estate of my estate when I'm dead. And the attorney would draft a document and then have that will witnessed by two witnesses, and my signature will be notarized. But remember, it does not go into effect until I die. Now, when I die, somebody, the personal representative, will hire the attorney and say, hey, Abe died, and we need to open probate. Probate happens to be a legal process where the will is given to the judge at the probate court and says, the attorney will usually do this and say, Abe's dead, here's his will, here's the personal representative, and can you please verify that this will is valid? So the judge will, through the probate court process, determine that the will is legitimate and that the heirs have the right to inherit the property from me through the personal representative. Probate, one, costs money. Second, it takes time. And the third, all the probate documents and records are open to the public. Anybody can see the documents. So that's some of the things that the people don't like about probate, because one, it costs money. Second, it takes time. And third, it's open to the public. So if I have a will, it goes through probate. If I don't have a will, then it goes through probate anyway. But usually my closest relative or someone that's related to me would call an attorney and say, hey, Abe died. He didn't have a will. So it's what we call, I died intestate. Whereas if I died with a will, I died testate. So testate, I died with a will. Intestate, I had no will. So then who gets my assets? State of Hawaii has a very complicated set of laws that says the closest living relative will get the assets in certain percentages. It's called the laws of descent. And the judge will say, hey, Abe died without a will. So I have to appoint an administrator to handle the estate of the decedent. So who's going to be the administrator? Probably someone that's related to me and that is somewhat financially savvy or is legally competent. So the judge will appoint the administrator. Administrator will work with the probate attorney, and then hopefully the process will go through probate, just like if you died with a will. So remember, if you died without a will, you died intestate. If you died with a will, you died testate. When you do the will, you have to be 18 or older. You have to be legally, mentally competent. And you also have to be willing to write that will before you die. Otherwise, it won't work, right? If someone dies without a will and has no heirs, and no one's opening probate because there is no heir, the state law says that after 15 years after I die, and there's no will and there's no heirs, then all of my assets will escheat to the state of Hawaii. The state of Hawaii will get my assets if I died without a will and without any heirs. So does that happen often? Probably from time to time, because someone might have no children, no spouses, no heirs, period. And that's what they call escheat. When someone dies, the properties that they own in tenants in severalty and tenants in common are subject to the probate court. If I own the property in joint tenancy or in tenancy by the entirety, because there's what they call a right of survivorship, the survivors on title will get the property and the will have no control over those properties that are in joint tenancy or tenancy by the entirety. When a decedent leaves a gift of real estate by will, it's called a device. So devisor is the one that made the will, and the person that's receiving the gift is called a devisee. So in real estate, when they inherit property through a will, devisor and devisee, which is kind of interesting because we never hear about those words except in probate court. Now, if you want to make a change to the will, it's called a codicil. And a codicil has to be drafted to say, hey, you know my original will? I want to disown somebody, or I want to add somebody. So the codicil should be drafted by an attorney again and make changes to the original will. The seminars that I've been to, the attorneys recommend that you don't do codicils, that you do a new will to say, this last will and testament is to supersede all previous wills and codicils so that you only have one document, which is the final document that you want to give to probate court. Because sometimes the codicil could be lost from the original will. So if you made the codicil that you disinherited someone and they lose that codicil, then in the original will, that person will still be the heir. So this gets a little hairy if you're going to disown somebody in a will through a codicil. So the recommendation is do a new will with a new will to supersede all previous wills and codicils. Again, you should have an attorney draft these documents. There's what they call a holographic will, where someone just wrote the will. No witnesses, no notary. And usually in Hawaii, I've been told that a holographic will is not recommended and not recognized by the state. In closing, in this section, one of the most famous probate cases that occurred was a fellow named Howard Hughes, who you might remember as being an eccentric billionaire. He died, and his residency was in California. He was a billionaire. No children, no wife, parents are dead. And he had no will. He had no trust. So when he died, 34 wills came into the probate court system. It took over 30 years for the courts to determine that all of the wills were fake. So who really finally ended up with his assets? His cousins. That were what we call the laws of descent. They were the closest living relative. So if you want your estate to go to specific people, you don't want to have intestacy. Because in Howard Hughes' case, I'm not sure that he wanted his cousins to inherit his hundreds of millions of dollars. So care must be taken to make sure that, one, you get a will, and make sure that it's a testacy and not intestate will, and that you clearly determine who the personal representative will be and who's going to administer the estate of the decedent once you pass away. Hope this helps. Aloha.